Okay, ready when you are. Good afternoon.
Good afternoon, Your Honor. How are you?
How are you?
I'm doing well.
Good afternoon, Your Honor.
Hello. Ms. Clifton, when you're ready.
This is case number 24015-435 NF, Multicare Health Center versus USA Underwriters Insurance Company.
Council appearances for the record.
Good afternoon, Your Honor. Muhammad Musa, on behalf of plaintiff.
And good afternoon, Your Honor. Kyle Macbeth for defendant.
Okay, let's start with the nerval matrix.
Yep, this is a motion. It's unopposed. I believe that you're probably familiar with it, but their own study says it's not efficacious over placebo, and so I would ask that the nerval matrix be dismissed.
And the court is very familiar with this, and the court has ruled on these motions on numerous occasions. And the court has previously made a determination, finding the evidence in light most favorable to the non-moving party, that the nerval matrix machine has not proven to be efficacious, and the court grants this motion routinely, dismissing the claims as they relate to the nerval matrix machine. So the court will grant that motion. So that's granted, and the motion is granted, but it's a partial.
Thank you, Your Honor.
Okay. Let's go on to the more complex one, the rescission.
Yes, Your Honor. I guess without restating everything in the motion, this is a rescission motion where the patient was the named insured and failed to disclose all resident relatives on the policy application. As stated in the attached affidavit, the policy would not have been written if USA Underwriters had been aware that the applicant had not identified all resident relatives. And so we're asking that the rescission be granted. And then as far as the balancing of the equities, I guess I would just rely on my brief unless there's other questions that the court has specific to the balancing.
Mr. Musa?
Your Honor, not to belabor the court, but we do understand that the general rule to constitute actionable fraud, and there are 5 total factors. And in short, the first one, the party against whom fraud is asserted must made a material misrepresentation. 2, that it was false. 3, that when he made it, he knew it was false or made it recklessly without any knowledge of its truth. 4, that he made it with the intention that it should be acted upon by a plaintiff. And number 5, that plaintiff acted in reliance upon it. And 6, that he hereby suffered an injury. Each of these factors must be proved with a reasonable degree of certainty, and all of them must be found in order to exist, in order for them to be found. And Your Honor, as it relates to this matter, the defendant has failed to demonstrate how the material misrepresentation led to a suffering of an injury. And there must be a suffering of an injury. We do have by case law pursuant to the Michigan Court of Appeals that is held in Howard versus Alum General that proven misrepresentation unrelated to the loss that occurred do not create the requisite injury to implicate any equitable relief. On this matter, there are no issues with coverage. There was no issue relating to the injury. There's no issue relating to that of the accident. Therefore, there is no requisite injury to implicate any equitable relief that could be provided or granted on the behalf of the defendant. We have there's nothing to substantiate that the claimant on this matter knowingly made these false statements or intentionally made these false statements or willfully made these false statements for them to amount under the standard that's required by the no-fault law, that they must be made knowingly or intentionally. And Your Honor, we also do understand that the claimant on this matter presented and availed themselves to a deposition. Had this person wanted to intentionally or knowingly make false accusations or statements, they would have remained consistent with what they presented in the application for benefits. And because the deposition was made, the claimant on this matter clearly eradicated, reconciled, and rectified all the statements that were made from the application of benefit juxtaposition to that of the deposition. So clearly, The claimant never had the intention to willfully make false statements. Otherwise, they would have either, number one, not availed themselves to deposition, or would have remained consistent to what they asserted in the application for benefit. And lastly, Your Honor, we do understand that there was a refund. However, the refund was not cashed, to my knowledge, to effectuate the rescission. And we do understand a mutual rescission may be inferred from the conduct of the parties, clearly evidencing their intention to treat the contract as at the end. And because that refund was not cashed, my client the claim on this matter did not effectuate the rescission for it to be effective today. Therefore, we kindly ask that this honorable court deny defendant's motion for summary disposition.
Yes, Macbeth.
I think a lot of those arguments are maybe were misstated in the response motion. There was not a deposition. There's no application for benefits. I think maybe Mr. Musa's referring to some arguments that maybe had been made in response to a MAIPF application and inconsistencies. That's what it sounds like to me, because it's not the facts of this case. In this case, the statements it was a recorded statement that's attached as an exhibit to my response. And it's not that knowing and intentional standard that applies in the MAIPF context. Here, the standard is knowingly or recklessly. And just yesterday, I mean, if it's material to the court, I can attach it, but it just came out yesterday. Court of Appeals upheld the rescission on the issue of failing to disclose resident relatives. And in that case, it was, I'll give you the name just so that it's not ambiguous, but it would have been Tamaya Allen versus USA Underwriters, unpublished opinion of the Court of Appeals, case Court of Appeals number 374174. In that case, the argument was made that the question was confusing or to some extent confusing, I guess is what they were trying to say. And the court said, well, then you didn't read it carefully. It's reckless if you don't disclose or say that you don't know who's living with you. It was her fiance in that case. But since it's not attached, I don't want to go too deep into that, other than to say that the intentional standard that was referenced in argument, I think, is the wrong one. In this case, it's intentional or reckless, and obviously Miss Hicks knew who she lived with and said so shortly after the accident when she had that recorded statement. And so for her to have put in her application,
You said she,
coverage.
and now let me make sure I remember, because yeah, I read like I had another motion. I want to make sure I'm not confusing this. This was her grandmother, right?
Yep. Yes.
Did she live with her grandmother or her grandmother lived with her?
They lived together. I guess I don't recall that it's stating who owned or rented the house, but they said that they lived together. And I can pull up that part of the transcripts.
Tell me where, because I have it. Just tell me what pages I want you.
It would be page 3. And then so it would be the top of page 3 and then at the bottom. It looks that it was highlighted. So hopefully the highlights came through clear and you don't have the black and white.
I just moved back from here. Where was this policy? Was the policy written in Michigan? Because
Yes,
she
Your Honor.
said she moved back from Arizona.
Yep, Roseville,
She came
Michigan.
back September. Roseville, what's your home address? September of this year. Just moved back from Arizona. Her grandmother and 2 children. Mr. Moose, do you have anything to add?
Again, Your Honor, the recording, it doesn't necessarily give any credence as to whether the grandmother lived with the claimant or the claimant lived with the grandmother. Again, the standard is knowing. And because we have a recording with the statement similar to what Brother Counsel had said, there's a contradiction. And we can always assume because the recording came later than the application that was presented, we do understand that there was the claimant had the intention to reconcile any potential inconsistency that may have appeared. And because the claimant made the intention to reconcile any inconsistency, it doesn't amount up to the standard of knowing. The claimant did not knowingly make it. And lastly, Your Honor, again, as stated before, although all because there's a refund, the claimant has to effectuate that refund by cashing that check. And we have no evidence, brother counsel did not put forth any refund check presented in there as their exhibit and their motion for summary disposition for the rescission to have been effectuated. Therefore, there's no mutual effectuation between the party of defendant or the claimant for them to effectuate the rescission.
Okay, let me, because I'm looking at these dates. It appears that the policy was written in November of 23 and the accident was, wait, maybe I'm saying it backwards.
No, you have it correct. November 2nd, 2023 was the application. December 15th, 2023 was the accident. And it would have been September that they moved back to Michigan, I think is what it said
Right,
there.
September of 23. With the rescission, you come back after the fact a lot of times and come forth, but this policy was in effect, and it looked like she tried to do the right thing from when she moved back from Arizona immediately and get the correct coverage for her vehicle because she moved back in September and within 60 days she had her coverage. And I don't see in terms of the intent to defraud, and what about the intent though, Mr. Macbeth?
Again, I think that that's a conflation of two different standards for rescission. The standard that applies to this is a common law rescission, which has those 5 elements that I think Mr. Musa accurately stated, that there was a misrepresentation here. I don't think there's any dispute that there's a misrepresentation. Specifically, it was asked, who do you reside with? And she said alone and didn't disclose the grandmother. Second, so that's, I don't think, disputed. Second is the false, that there's a misrepresentation. Third is the material, which is satisfied by the affidavit, which states that the policy would not have been written, but for if they had, let me restate that. The policy would not have been written if USA underwriters had known that she had not disclosed all of the residents of the household. And I put all the reasons why that's really important these days, because one, that's somebody who'd be driving the car. Two, that's somebody who might be claiming. And three, they often have.
Well, wait, let me stop you right there. Someone who, see, the thing is I think we might have to have a question. How old is this grandmother? I don't know these questions. Grandmother may not have been of a driving age. I don't know. So you're starting to suppose things that we don't even know, and then you're saying the driving age. I don't know anything about this grandmother because the individual who did the EUO asked the question, who do you live with? And then they started to ask her birth year, and she wasn't sure, and they just blew by that. Because that would have been critical. If the grandmother is, 80, 85 years old, maybe she doesn't drive. Maybe grandmother does, there's questions. Like I said, that individual who took her EUO started down that road and then switched gears. And to me, it's like that was a critical piece because she said her grandmother, we don't know anything about this grandmother. And I just have a problem with, like I said, the policy was written. It appears that Ms. Hicks attempted to do the right thing by once she moved back to Michigan to get insurance for her vehicle. And then we have the situation here where she needs her coverage, like I said, the individual asked, then they switch gears. It's like, to me, that would have been critical. Just to
I
say
can,
that she lives with her grandmother, and then you ask the year and you don't find the date of birth. And he thought that and I see, because they asked, what was the date of her birth? She said she didn't know the year. Unknown year, that's okay. And then you say you live with your children. How old are your two children? 12 and 6. They didn't ask how old the grandmother was. The thing is they started down that road and then they cut it off because they said, okay, we got her. But we don't know anything about this grandmother. He asked all the pertinent questions as it related to the children, the ages of the children, but then they cut it off when they asked about the grandmother. And and the thing is I think she was forthcoming in terms of whether or not she had one of the, I thought, and then correct me if I'm wrong, one of the elements is the intent to defraud, right?
no,
I thought,
that's not an
give me,
element. I disagree.
okay, give me the elements again,
One, material misrepresentation.
right? That they knew it was false,
Two,
right?
that it was false.
Okay,
That it was made knowingly or recklessly
okay, okay.
with the intention
Knowingly or
that it be
recklessly.
relied upon and that it was relied upon and that there was the injury, which is the writing of the policy based on inaccurate information.
Okay, now in terms of knowingly or recklessly, you're asserting that this new case law said it was reckless because of what?
Um, yeah, I mean, I guess I don't know that it's a new case law. It just supports what I think has always been the
Well, no,
standard.
you
But it
said
said,
it was a new case. Well, I'm
oh,
sorry, new
it's
case.
new. It's
You
just
said it
not
was a recent
established.
case, unpublished
Yes,
case that you recently got from the Court of Appeals. Let me correct myself. I'm sorry.
yes, I apologize for the confusion I caused. And they just said that it's reckless. They said that when, let me see if I can read from it. Plaintiff insists she did not, and I'm reading from page 3 of the opinion. Plaintiff insists she did not knowingly make a false statement in her application for insurance because she did not know her license was suspended. That's the suspended part. There's two pieces of this. Um,
And you said it was her fiance, right?
correct.
Okay.
Yeah.
This is distinguishable.
Okay, so then now I'm on page 4. They're talking about the fiance. Later testified she was living with her fiance, and this is the question in the application was unambiguous, and plaintiff's insistence that she misunderstood the question merely supports that she did not read the question, but instead answered it recklessly without any knowledge of the truth. Um, and I would say the same is true. It's not like she's being asked to to recall some long time ago. This was a December statement from a November application. She obviously knew who she lived with at the time she made the application, or she made it recklessly. I don't know how you can say it's not reckless. I think she's a 32-year-old. If I'm correct?
But like I said, you're
And
missing the other piece of the puzzle here, and I don't know the answer. Whoever this was who began down the road with the EUO, he asked how your grandmother's date of birth and what year she didn't know. He didn't ask her how old grandma was, and then he went on to ask her about your two children. He asked the ages of the two children, and the thing is that in terms of it being reckless. I don't know. To me, that's something that I'm not prepared to grant it because who is grandma? How old is grandma? Is grandma, she lives with her grandma. If it's something that's maybe I'll dismiss it without prejudice and you can refile it. But I think that they went to the line and then they crossed it with the kids, but they left it ambiguous to me with when it came to grandma. And the thing is recklessly, if grandma's of a homebody senior age, maybe she didn't think that it was important. That's not reckless. That's not being reckless, and it's not knowingly. So I think that in terms of the case that you raised relative to the Court of Appeals decision where they were talking about the suspension and her license was suspended and she lived with her fiance, that's clearly distinguishable, especially when we don't even know anything about grandma. I'm not prepared to, I'm not, and then, and additionally, the check wasn't, I'm not prepared to grant it at this time. I don't know where you all are in terms of, yeah, we had a settlement conference today, so I don't, and I don't know, I know I was, making the statement for Mr. Moose's case. Mr. Moose, is there something you want to add?
Your Honor, again, like how you said, the elements of fraud requires that the claimant make a statement that he made the intention that it should be acted upon by plaintiff. And number five, that plaintiff acted and relies upon it. We have nothing in the evidence to substantiate that the claimant intended to make a statement with the intention to defraud or falsely procure benefits from the defendant on this one, Your Honor. And again, I'd like to add that how under the application for personal auto insurance, it does clearly say under household members that you list all individuals identified as listed below are rated as drivers unless otherwise excluded. Again, we have nothing to assume that the grandmother was intended to be a driver under this policy. For them to assume just because there's a grandmother involved somewhere somehow that we could assume that she is eligible to drive. Because it's stated over here in verbatim, all individuals identified as listed below are rated as drivers unless otherwise excluded, we can fairly assume that nothing reckless was being stated. Why? Because the grandmother may not be of age to operate a vehicle. And number three, and lastly, like how you said, as previously stated, Your Honor, again, all because there was a refund and it needs to be cashed in order to be effectuated. We have no evidence that the refund was cashed for it to be effectuated. And with that, we kindly ask the Honorable Court to deny defendant's motion for summary disposition.
Take them and slide most favorable to the non-moving party. Court's going to deny the motion. Let's stop recording so we can, I know Mr. Macbeth might want to do, so we might have to put the settlement conference over. We'll let Mr. Macbeth make a determination what his client's going to do. Give me